Thank you, Michael. Good morning, everyone. Thank you for taking the time to connect to this session. I hope that you will find value, and I hope that you get what it is that you're looking for in having registered for this session. I want to thank Startwise also for making this possible and doing their work and doing their best to support SMEs and to support entrepreneurs. You know, when I was approached and I was requested to be part of the group of mentors that are going to run these webinars, and I was asked what the topic was that I was going to speak about, immediately I thought about what it is that I would want to impart and what kind of value I would want to create. And as almost immediately, the first thought was, I would want every entrepreneur that comes onto the session to leave the session with a different perspective about the law, with a different perspective about what the law is, and with a different perspective about what the law can do in supporting you to grow your business. So without wasting any more time, I want to just give you a brief background about who I am and just where I come from. I've always had a passion and love for law. It stems from my father, who loved law, and so we used to sit literally until 9, 10. I don't even know if that was a good thing, watching legal shows. And in that day, we watched things like Law and Order, Ellie McBeal, and we would sit through long trials like the O.J. Simpson trial, something I used to sit through when I'd come back from school. And it developed in me a love for law. But I think the reason why I did that was because I understood that the law impacts us in our everyday lives in different ways. And the world of business is no different. And so it made me want to know, is there no audio? Can you hear me, Mafadi?
You all good, Bindi? We can hear you.
Oh, okay. All right, excellent. And it made me want to know how I can be proactive in engaging this law that impacts me on a daily basis. So when I finished matric, I went to the University of Johannesburg. It was called RAU in those days, and I studied my BCom law degree. And that's where I first saw the intermingling between the law and commerce. That legal transactions, or business really is a series of legal transactions, and how one can, by knowledge of the law, be able to impact commerce and impact how business happens. I then did my LLB with the University of South Africa, UNISA, and one of the first things that happened was that when I began to work, I got exposed to the process of negotiation and conclusion of contracts. So the ability to apply what I had studied by being able to take legal concepts or even commercial concepts and be able to reduce them in writing and put them in a document that can regulate that relationship was something I found exceptionally interesting. And it's just an area of law that I specifically love, and one that I'm going to spend quite a lot of time on today is the issue of contracts, because I firmly believe that most entrepreneurs on a day-to-day basis are dealing with some type of contractual relationship. And it's really important to be empowered to know how you can use that contractual relationship to not only protect and preserve your business, but to grow it. And my purpose for taking part in this webinar was, like I said, the need to show a different perspective and the need to outline how we can be more proactive in using the law. So I hope that everyone who comes here today can take something back with them. They can go back and look at their business in a more critical way, but empowered with more knowledge to be able to better manage the risks that their businesses are exposed to. So I'm going to touch on a few things today. I'm hoping to leave enough time at the end for questions and answers. And above all, enjoy. Believe it or not, the law is something you can enjoy. It's something you can enjoy interacting with. And what I hope is that you will enjoy this session and that it will derive value. value that you can take back to your business and plan. Okay, so starting point, the law has an impact on everything we do. If you think about COVID-19, if you think about what happened when the COVID pandemic hit the country, the world, and the series of lockdowns began in March 2020, you remember that essentially what happened was that regulations were changed, and the Disaster Management Act was invoked in order to change regulations, in order to effectively manage or manage the risks associated with the COVID-19 pandemic. And so we went in what felt like overnight, from being able to gather with friends, being able to gather with family, see our parents, go to meetings, go to conferences, network. And all of a sudden, in what felt like the blink of an eye, we were locked up in our houses under lockdown level 5. And a lot of businesses were not prepared. A lot of individuals generally were not prepared, but in particular, a lot of businesses were not prepared for that outcome. We didn't anticipate it. And so we found ourselves, our doors were closed, our businesses were closed, we couldn't operate. You had obligations, you had certain opportunities that you were in the process of taking advantage of, or certain obligations you were expected to comply with, and you couldn't do it, all because regulations were changed. So whenever you think about the law, I think the COVID-19 period is a perfect era, or a perfect period to reflect on how impactful the law can really be on our ability to run our businesses and on our ability to engage in commerce. That was an example of the impact of the law. And what that tells us is that ignorance of the law is absolutely no excuse. So we can't afford, within our respective environments, within our respective industries, within our respective landscapes, we can't afford to not be aware of the legal provisions that impact on our businesses. We also can't afford to not be aware of the opportunities that underlie or that lie in the law. Because as much as there's the issue of risk and managing risk and more of compliance, being more reactive, there's also, I believe, an opportunity to be proactive and to leverage the law to grow our businesses. So always bear in mind that ignorance of the law is no excuse. And even if you're found to be in contravention of the law, one can never say, I didn't know. We are held accountable because the law applies to us. So always bear in mind, you see with the image that we've used is the picture of Lady Justice literally in this man's living room, because the law impacts us not only outside, but literally in our home and in our businesses as well. So in my view, it can play one of two roles, one of being a regulator and one of being an enabler. I'm going to focus more today on the law as an enabler. The regulator talks to issues of compliance, and I think we all know a lot about that. We know about, for example, submitting your annual returns is an example of the law as a regulator. You know, the Act requires that you submit your returns. If you don't submit your returns of a certain period of time, the government has a right to begin a deregistration process in relation to your business. So there's an obligation, you have to comply, and that's just what it is. The same is true of tax. So the law as a regulator issues around your annual e-filing. I just got my notice a few days ago that I need to file my tax return for the business. And so these are things we need to comply with. And if you don't, there could be penalties, and even criminal consequences if you're seen to be avoiding tax or to be evading tax, rather, excuse me. So we all know about that, and you know, it's always something that if you even reach out to us on the platform, on Startwise, we can always look at your compliance requirements and support you there. But what I really wanted to focus on today was the law as an enabler, which is something that we don't often hear and we don't often exploit or leverage. Okay, but before we do that, I wanted to deal a little bit with risk. Business is a risk environment. It's natural and it's really part of the process. And one of the areas that I want to focus on is legal risk. And just a very simple definition is that risk is a situation that involves exposing or exposure to danger. So exposure to something possibly going wrong. So in a simple phrasing, you could ask yourself, what could go wrong? What is most likely to go wrong? That's probably one of the easiest ways that one can describe risk. And legal risk pertains specifically to what could go wrong as a result, either of non-compliance with the law or not acting in accordance with any legal obligation. I would like you, when you have the opportunity or when we leave this session, to really take the time to look at your business. And I'm going to go through in the next slide the types of risks, legal risks that a business can face. And if you can just take the time to sit down in your planning sessions or in your reflection sessions and ask yourself, what are the legal risks that currently face my business? And how am I mitigating them? How am I managing them? It's very important that from time to time, we take the time to evaluate the risks in our business and how we are proactively managing them. So there's a number of risks that legal risks that could face your business. One is regulatory risk or compliance risk. So these are the risks relating to non-compliance with regulations. And with the law, basically, I've already referred, for example, to the filing of annual returns, which finds its origin, which finds the expression from the Act, from the Companies Act. We have a responsibility to file returns with the CIPC on an annual basis, and the risk is if you don't do that, over time, your company could be deregistered. And it could have follow-on risks. For example, if you apply for funding, I know, for example, within the public service, that if you apply for funding within the public sector or with government departments, one of the things they want is proof that you are paying your annual returns. So you could have an exceptional concept, you could be a great candidate for the funding, but one of the things they want to see is, are you tax compliant? Are you paying your taxes? What's your tax compliance status? And are you filing your annual returns? So beyond the issue of penalties and beyond the issue of possible deregistration from a CIPC point of view, it could have follow-on consequences in terms of financial risk or the risk of being able to attract capital to grow your business. So regulatory risk and compliance risk is non-negotiable. It's absolutely important. And it is important that you remain abreast of the compliance or the regulatory requirements within your specific industry. And it's vast. Different industries have different regulations, have different requirements in terms of what you need to comply with. I mean, we're thinking about industries in steel, manufacturing. Different environments have their own regulations. So it's important that you are aware because they do apply to your business. Whether you know it or not, they do apply to your business. So regulatory risk is one of those. I'm also thinking, just off the cuff around occupational health and safety. And this became a huge issue during the pandemic because employers now needed to think about health risks. If I don't have a vaccine, if one of my employees doesn't want to vaccinate, what do I do? Mandatory vaccinations. Do I force an employee to vaccinate? And if they don't want to, what are the remedies and what are the risks of having an environment with unvaccinated employees? These were some of the issues that a lot of employers were faced with. Because occupational health and safety is primarily, in terms of the Act, a requirement that is put on the employer. That the Act says an employer or business owner in this case, which is us, has a responsibility to create and maintain a safe working environment. So there couldn't be ignorance. You had to know what the Act says. You had to know what your responsibilities are in terms of the Act and how can you mitigate against the risk of not complying with the Act and possibly not complying with the regulations. So regulatory risk, compliance risk, absolutely important. And when you do your evaluation during your time of planning and reflection, think a bit around that. Just create a list of some of the risks you think are not being managed, there might be gaps, and see how you can manage those and how you can mitigate those. Contract risk. Contract risk is probably one of the areas that I see most in dealing with our clients. The bulk of the work that we do has to do with contracts. My apologies. The bulk of the work that we do has to do with contracts. And whether it be a situation where there's now a dispute and there was not a contract in place, or a situation where an entrepreneur wants to engage in a transaction or wants to take advantage of a specific opportunity and they're presented with a contract, and they need to consider their risk exposure and how they're going to manage that risk in terms of that contract. And it's a huge risk, essentially, not having a contract in place or even having a contract that doesn't effectively manage the risk. This also includes not complying with contractual obligations. For example, you might be looking to lease space for your business, and it's a rush thing. You want to take advantage of the opportunity. You want to take advantage of the opportunity. I need to stop reading the chat. Sorry, Michael. You want to take advantage of the opportunity, and you don't sign a lease. You quickly sign it. You don't read it rather. You quickly sign it. You put it in a drawer somewhere, and along the line something happens, and you don't comply with an obligation. You are now at risk. Your business is exposed, and so it's important to not only conclude proper agreements, but it's also very important that you know what it is that you are contracting to. So contractual risk is important, and I would like us to look and say, where have I signed contracts, or where do I have obligations, and how are we making sure that we are, first of all, complying with our obligations in terms of those contracts, but also enforcing our rights, because a contract will typically give you rights and obligations. So it's very important. Contracts are probably one of the most critical areas for an entrepreneur when you start your business and as you grow your business. And they do become sometimes more complicated as you grow your business in terms of managing risk. Dispute risk. Dispute risk essentially is just the risk of a dispute arising. It could be a customer or a client that's unhappy with whatever service or whatever product offering that you might have given them. It could be an employee who's unhappy with certain issues, who's disgruntled, that could give rise to a dispute. So it's always important to keep an eye and keep an eye on possible dispute risk and how you manage that. And then lastly, reputational risk. This is just basically the result of a decline in the reputation as a result of legal actions, whether it be you being sued, whether it be an internal legal dispute. Just how are you perceived in terms of dealing with legal risk and dealing with legal actions. So please bear these risks in mind and think about how it is that you could possibly be at risk, or whether there could be risk exposure in your business, and then sort of make a note around how can I begin to manage or mitigate these risks. So that's very, very important. And the quote is telling. It is often said that running a business means taking risks, and the biggest risk an entrepreneur can take is not to think about risk at all. And that's what makes this in the UK. Why is it a risk? Because whether or not we are cognizant of the risk, it still impacts your business and still poses a danger to your business. So it's very important that you be aware of the legal risks that affect your business, and really put measures and interventions in place to be able to mitigate those risks. Okay, so a huge underlying theme, and maybe the main theme of this session today, is contracts as a tool for growth. As I mentioned to you, contracts form the bulk of the matters that we tend to deal with within the SME sector, and so I wanted to make that a focus. Essentially, a contract is an agreement. It can be verbal, it can be written, it can even be tacit, and we'll explain what that means, and from which flow certain rights and certain obligations. So, in reality, a contract can arise even though it is not written down on paper. So if one day I wake up in the morning, I knock on your door, you open the door, I say, hi, I'm here to clean your house. You let me in, I clean the house. At 4 o'clock, I wait. You open your purse, you give me 100 rand and I leave. I come back tomorrow and I do the same thing until, for the week, for example, so Monday to Friday. I do it week on week, I do it month on month. Therein arises a tacit contract of employment. So even though we might never have sat down and signed anything, the conduct of the parties gives an indication that there was an intention to create a working relationship by virtue of our actions. So by me coming and presenting my labor or myself to work in your house and you in turn remunerating me for it, in many ways we meet the definition of what it is to conclude a contract of employment. Because what is a contract of employment? You present yourself for labor, or you present yourself as labor, and in turn you are remunerated for the work that you do. That's a very extreme example, and it will probably never happen in most cases. But that's one of the ways in which a tacit contract can arise. And that's what tacit means. It means that it hasn't necessarily been spoken in word or even written in word, but through conduct and action, you effectively establish a contract of employment. So it needn't necessarily be a written contract. There are a few exceptions where that's very specific formality that I won't touch on here today. Things like when you sell land, elimination of land, and issues around suretyship, that's different. It's a very, very small area of law where there are really clear formalities. But in many instances, contracts can arise even though the contract is not written down and signed. The problem with that is that whenever there are issues around disputes, which very often happens, the terms of the contract then come into dispute. And now parties have to prove their side. So I have to prove that, but you paid me and you let me come in every day, and you knew I was coming to clean, and you paid me the same amount, and I came in every Monday to Friday, and I came in every week, and I came in every month, and I did that for a year. And then out of nowhere, you told me to stop coming. That's a dismissal. And you would then have to prove your point. Say, no, I didn't realize you were coming. And so it creates a he said, she said dynamic that can really be lengthy in terms of disputes and can really be a very expensive process. That is why it's so important that whenever there's a contract that arises, it needs to be documented. Both parties need to know what it is that they're contracting to, what their rights and obligations are, and there needs to be consensus around what it is that they're entering into in terms of this contract. What will typically happen, is when there's a dispute, the court will first of all look at the contract and the terms of the contract in order to establish the relationship between the parties. So your contract is a critical document. Only where there's a need to either authenticate the contract or where there's a need to expound on certain provisions, where the courts typically call witnesses to come and give vocal, what they vocal evidence. But typically, a court will first of all, and most tribunals will want to see the contract first. What were the parties' intentions? What were they thinking? What were they looking to do when they entered into the contract? So it's very important that the contracts are written and that they are unambiguous, that they're clear, in order to make sure that there isn't any ambiguity or in terms of enforcing those contracts or in terms of dealing with disputes. Essentially, there are about five elements of a contract. Basically, it means there needs to have been an offer. So there needs to have been an offer. The offer has to have been accepted by the other party. So there has to be an offer. I'm going to sell, for example, my car to Michael. And I'm going to sell my car for 2,000 rand. It's an old car, not really sure, I'm joking, but it's an old car. I'm going to sell it to Michael. And in turn, Michael needs to accept that offer and say, okay, I'll take it for 2,000 rand. Then we have an understanding that this is a contract of sale. We're selling a car, it's for 2,000 rand. And this is how I'm going to pay. I expect you to pay cash. It's only 2,000 rands, e-wallet me the money. Then the terms are defined. They're defined in the contract. So there must be an offer, it must have been accepted, there must be consensus. And what the court has said is it must have been a meeting of the minds. So there must be a mutual understanding of this contract that we are concluding. I can't have a different understanding, and that is a totally different understanding. Who thinks it's a donation? No, there needs to be clarity that there was a contract of sale, that the parties understood that the car was being sold, and the other party accepted the offer and agreed to pay the 2,000 rand by e-wallet by a certain date, for example. So there must be consensus. Both parties must have legal capacity to transact, excuse me. So by law, they must have the ability to enter into a contract or an agreement that's binding. Typically, minors are not empowered to contract and bind themselves. So unless you are a major, so you're somebody who's 21 years and older, or you're an emancipated minor, you would not be able to bind yourself to a contract successfully because you don't have the capacity to transact. The same applies to people who, for example, might have a mental incapacity or who are not able to really make decisions or cannot be held accountable for those decisions, can't transact. And so the parties must have the capacity to enter into a contract and bind themselves. And that agreement must be lawful. You can never, ever, ever enforce an agreement that is unlawful. You can never enforce an agreement that is illegal. So any agreement that is intended to bring about an end that is unlawful will not arise. So it becomes null and void. It won't be, you can't enforce it. It's considered by law to be an unlawful contract. And I give you this list because as you go through business, and as you build your business and as you grow your business, please bear these issues in mind when you negotiate your contracts. Bear these elements in mind, check for them, tick those boxes and make sure that those things are in place before you sign a contract or before you bind yourself to a contract. So I just wanted to highlight that you are aware that there are certain elements that should be in place in order to bring about an agreement, and certainly to bring about an agreement that's binding and enforceable. Contract is a tool for growth, first things first. You know, a very important part of the process of concluding a contract takes place before. Takes place before you actually sit down with that piece of paper and sign or not sign. A lot of it has to do with you as an entrepreneur being clear on what outcome you desire from concluding that contract. It requires you to reflect and say, I'm selling my car. What is it that I'm looking to achieve in selling my car? Am I clear on the outcome that I want? Why? Because then it creates the parameters. It creates the parameters within which you operate. And you then know going into this contract how far you are willing to go and what you are willing or not willing to concede. It's very important because in the process of negotiating with the other party, it's easy to be pushed a certain direction that over time does not actually serve your best interests. So it's important to sit and say, what are my parameters? I'm not willing to go so far, I'm willing to go so far, and I'll be happy if I settle here. And then enter into that process of negotiating or concluding a contract with that type of clarity. It's exceptionally important. So typically there are 3 bargaining negotiating positions. There's a lot of information on the internet around negotiation. So, you know, when you have an opportunity, I think do read up on that, do some research. Why? Because very often within the course of business, you'll be negotiating something. Or you'll be in a position where you need to negotiate something. So it's important just to understand the negotiation processes, to empower yourself on how best to negotiate in such a way that you contract in your best interest and you don't find yourself contracting or entering into a contract that is not in your best interest. So very simple 3 things. your best possible outcome. This is ideal. So using the car example, I want 2,000 rands. That's really what I want. I want 2,000 rands for this car, and that would be my ideal outcome. Okay, middle of the road. Michael renegotiates. He says, no, 2,000 rand for that car doesn't make any sense. I'm not willing to pay 2,000 rand. I'll pay 1.5. I'll pay 1,500 rand for that car. Okay. Then I need to consider, okay, Michael's coming back. He's got a counter offer. He wants to pay 1,500. Really, I wanted 2,000 rands. But maybe, 1,500 is not an option. It's not something I'm willing to live with. I feel that this car is worth more. And that's the third portion, the absolute minimum. So I say, look, as an absolute minimum, I will accept nothing below 1,600. 1,500 just doesn't make sense. So I go back and I counter offer. I put my first offer, which was 2,000. It was rejected, and Michael came back with a counter of 1,500. Because I defined my parameters, I decided 1,500 is not an option. My absolute minimum is 1,600. But I wouldn't typically go back to Michael and say, I'll take 1,600. I said, okay, what is the middle of the road that I could be comfortable with? I mean, I wouldn't be elated, but I wouldn't be disappointed. I can live, I can accept it. I'd be happy to walk away with it. Okay, I'll settle on 1,800. So I'll go back to Michael and say, Michael, your offer I reject, but as a counter, 1,800 is something I'm willing to consider, because I know I've already defined for myself that I'd be happy to walk away with 1,800. Michael considers the counter. He says, I won't pay 1,800, but hey, I'll meet you somewhere, I'll pay you 1,600. So I can go back to my parameters and say, okay, 1,600, it's not ideal, I won't be elated, I won't even necessarily be happy, but I'm willing to live with it. And I say, that's fine, I'll take the car for 1,600. We have consensus, we have a meeting of the mind, it's a lawful agreement of sale, and we both have the capacity to contract. We've met the elements of the contract, we write it down on paper, or we document it with all the rights and the obligations and other provisions around disputes, defaults, what happens when those things happen. So we put that in our document and we sign it. It's really important as an entrepreneur to always know where your parameters lie, and to be comfortable to walk away, from a negotiation process if it becomes evident that you would need to contract outside of your parameters and not necessarily in your best interest. I just thought to add that in there because it is important, and it is something that we often face. And sometimes there's even a reluctance to negotiate. I don't think it's the most natural thing for many entrepreneurs to counter or to push back. But I think often once you train yourself to negotiate, and once you can substantiate why it is that you are countering, you find that you can really create a lot of value for your business by being a good negotiator. And so, as a side note, look into that, read material, because it could be a very valuable tool to be a great negotiator. Okay, so I need to hurry. Okay, and then I wanted to talk a bit about contract as a tool for growth in terms of attracting investments. We know that accessing funding is not always an easy thing, can be a very difficult thing. And so one of the other ways that you can raise capital is either through getting a loan, can be loans from friends, can be a loan from family, it can be loans from an institution, but you would typically then have to complete a loan agreement and the terms that need to be reflected in that loan agreement. These terms are not exhaustive, meaning that there could be other issues, because remember, a contract is two parties coming together and agree on a certain way to do things. So different scenarios may require you to add other clauses that better regulate that relationship. But a loan agreement tends to be very easy in the sense that you agree on the terms, you agree on the repayment schedule, you agree on the interest, you agree on the dispute resolution procedure if there is a breach. Typically a lender does not want to be involved in the day-to-day running or even the strategic running of the business. They want to loan you the money, and they want their money back with interest within the agreed time. So, if you go that route, just make sure that your loan agreement is clear in terms of these provisions. And then on the other end, you can also use contracts to attract shareholders or investors who sort of want to take up equity in your business. This is a slightly, obviously, more complicated process because essentially these people, investors, excuse me, then take up a part or they take a share in your business. And it's important to be able to have share agreements that clearly outline the roles and responsibilities, the roles of the shareholders, the shares that are being issued, at what value, at what price, what happens if you want to sell your shares. That needs to be in your shareholder agreement. What happens if a shareholder passes on? What happens to their shares? And also if there are already existing shareholders, if a new shareholder comes on board and acquires shares, what happens to the value of the shares of the existing shareholders? It's very important to be clear around dilution. There's a shareholder coming in, dilute the value of the shares. Those fine details are key whenever you conclude a shareholder agreement. And then typically when you're dealing with someone who buys or who comes in and invests in terms of equity, you'll find that they want to have some say, probably in terms of the strategic running of the business, because remember, they are watching over their investment and they want to make sure that they can recover returns from their investment. But these are some of the ways you can use contracts and leverage contracts to attract capital to your business. A very key issue for me is attracting suitable talent. Sometimes as entrepreneurs, there's a danger of one-man show, often for fear of committing to acquiring staff, because we know that South Africa has quite a robust labor legislation landscape and a lot of consequences. If you take employees on, there are certain obligations, and if you don't meet them, there could be consequences. So I wanted to talk a little bit about using a contract really as a tool for growth in terms of attracting suitable talent. There's the normal, traditional contract of employment scenarios. So a permanent employee that comes on board and they stay and work in your business indefinitely unless that relationship is cut off by them resigning or by you having to then terminate their contract of employment as a result of misconduct, if they do something that is wrong, or they become ill and cannot work or they're incapacitated, or you find that they're not compatible with your business. So that's just the normal traditional permanent employee scenario. Then you've got temp scenarios, and I think that the speaker who had this session before me probably touched on a lot of these things because her focus was on HR. But temp would be linked to either a project, so let's say you get a contract to do certain amount of work for 6 months, you might want to hire staff for that 6 months, and then when the contract lapses, when the project lapses or that 6-month period lapses, the contract will automatically lapse. Very important to make sure that also your terms in terms of how long the contract is, the scope of work, those terms are clear so that there isn't any ambiguity. After 6 months, you either have, if you have a temp employee and you terminate that contract before the scope of the contract ends, it could bring you into some legal challenges where you might have to then pay out that temp employee. So it's very important that you be sure that the terms in your contract are clear and are linked either to a specific project or linked to a specific term. But one of the things that I wanted to touch on today was the issue of the independent contractor. Now, this could be very helpful if you're starting out, particularly if you're bootstrapping and you don't have the money to hire a full-time staff or to commit to paying a full-time staff as a monthly salary as part of your overhead. So you could look at an independent contractor relationship where the independent contractor functions almost like as a service provider, as a contractor, and you become the client. And they then do work as required and invoice you, and you pay them on work done. The only important thing to bear in mind is that in that situation, you can't necessarily dictate or control the independent contractor in terms of how often they need to come into the office, how long they must stay into the office, in the office. So your locus of control is very, very, very small. But what you can do is use your independent contractor agreement to outline your deliverables or the deliverables for the independent contractor, and then you measure the work done based on how they respond or how they deliver in terms of those deliverables. And if you do that, you can really attract some great specialist skills, you know, as and when you need to, and be able to pay them for work done and be able to pay them in that way by using the independent contractor provision. I'm not going to stay here long. Again, strategic partnerships, just an opportunity that one can use to grow their business through strategic partnerships. I'm just thinking off the cuff around the relationship between Michael Jordan and Nike. When Michael Jordan joined or Nike as a brand ambassador, Nike was effectively a startup. And they had a very small market share because at that time, Converse was the sneaker that a lot of the basketball players used. And Nike wanted to penetrate and infiltrate that market. And they did a collaboration, and Michael Jordan became the brand ambassador. And look what that did for Nike. I mean, it established Nike in the most incredible way. And Nike has continued to profit off of that relationship and off of that brand association. And so has Michael Jordan. So there are always opportunities to grow your business through strategic partnerships and through collaboration. Also mergers and acquisitions. This is mergers when two businesses come together and they merge. Acquisitions when you buy a business. It's always important as SMEs that we bear in mind that these are not opportunities that are only open to large businesses. That small businesses that have a common a focus, that have a common value, that have similar ethos, can actually leverage the power of mergers and acquisitions to grow their brand and to grow their offering. So it's very important that when we are building our businesses, we are cognizant of these opportunities that exist, and that they're not only left for big clients or excuse me, for big corporations, but small businesses can come together and leverage whatever value they've already created to build something bigger and something more impactful in the market. And then lastly, I wanted to also look at contracts for tool for growth in terms of increasing your revenue or market share by looking at franchising. Franchising is a lovely way. So once you've built your business and you've built your brand and you've built your know-how, you know, and you've refined your IP, it's a great way to grow your market share quickly and with less risk. Because what happens when a franchisee takes on a franchise, they take on the financial risk because they have to then, whether they have the money, they have to buy the franchise or they have to get it financed. But you continue to grow the brand. And as a franchisor, you can then benefit from the fees, the license fees, the marketing fees, etc. And you continue to still maintain some type of control over your brand. It's a great way to grow. So also as an SME owner, bear that in mind as you're building. Think 2-3 years ahead. If you think you're at a place, you'll be at a place in a year or two where you need to consider franchising to grow your brand. Start planning around that and start putting together this that you need to grow your brand through franchising. I think what's important is that sometimes when we are building our businesses, we focus on what's happening here because there's so much to deal with. You know, you're putting out fires, you know, trying to grow your market, you're marketing, you're doing this, but let's always remember to also think 2, 3, 4, 5 years ahead and already start to plan and to put building blocks in place in order to build larger, sustainable organizations that can create employment and grow our economy. So again, a key issue there would be, I went too far back. A key issue there would be slide. So, excuse me. A key issue there would be your franchise agreement. Would be a franchise agreement, making sure that it's clear that the terms around roles and responsibilities are clear, and then you can grow your brand that way very quickly. I wanted to just put a franchising success example, which was Sorbet Nail Bar, established in 2005. Sorbet receives over 40 franchise applications on a daily basis. The demand has been so high. And as of 2019, its turnover was 500 million rand. But at some point, it was a startup. At some point, it was a small business. And through the franchising model, they have been able to grow their business considerably to a 500 million rand business.